A very good afternoon to you and welcome to In Focus with Silvana Pavlovska, broadcasting from Melbourne, Australia. We're continuing our series dedicated to the Macedonian question and in particular the scholarly publication of Prof.d-r Igor Janev titled The Prespa Agreement as Cultural Genocide of the Macedonian National Identity towards the termination of an illegal treaty. In the last few weeks, we have covered 5 of the chapters contained in this publication. A publication by Prof.d-r Igor Janev, as I said, an eminent, renowned author, expert on international law. Today, we're going to start chapter 6. Now, chapter 6, I already mentioned in the previous broadcast that it does contain the conclusion and some final recommendations from the professor. In the present book, that is this publication, we have analyzed political and legal aspects related to sustainability and legality of the Prespa Agreement, or PA, as it is known as well, concluded between Macedonia and Greece on 17th of June 2018. We started this research with analysis of the legal grounds of the Prespa Agreement and particularly aspects of the United Nations Security Council resolutions 817, 1993 and 845 from 1993. In which, in quotation, the name dispute in quotation was imposed on Macedonia as a framework for conditioning during its admission to the United Nations membership, especially conditions: 1, to accept a provisional denomination, the former Yugoslav Republic of Macedonia, the FYROM, for use within the system of United Nations only, and 2, to negotiate the state's name with a country that did not recognize it at all. We have argued, says the professor, that the imposing of additional conditions in the Security Council Resolution 817 to an applicant state after affirming that the applicant fulfills the admission laid down in Article 4, Paragraph 1 of the United Nations Charter is in severe violation with the advisory opinion of the International Court of Justice of the 28th of May, 1948, accepted by the General Assembly Resolution 197/3 of 1948 as interpretation of the Article 4 of the United Nations Charter. In view of these 2 United Nations documents, the Security Council Resolution 817, 1993, is a blatant breach with the UN Charter Articles 1, Paragraph 2, Article 2, Paragraph 7, and Article 4, Paragraph 1. The first 3 belonging to jus cogens norms of international law. The Security Council Resolution 817 is therefore an ultra vires act by the United Nations, violating the peremptory norms of internal law, and as such cannot serve as legal basis for the Prespa Agreement or for any other treaty according to general legal principles ex injuria jus non oritur. In our research, we found that the origin of an imposition, the illegal framework for negotiations defined by the UN Security Council Resolutions 817, 1993, were absence of essential knowledge of the representatives in the UN Security Council in 1993, who did not know that additional conditions to the generally prescribed enumerated conditions in Article 4 of the Charter could not be laid down to the applicant state. In the Macedonian case, this candidate state applied to the UN membership with its constitutional name. Okay, those of you who want to check that, you can see United Nations document S/25147. The UN Security Council resolutions 817, 1993, reported that all conditions related to the article were met. All conditions were met, and still imposed despite that, they imposed additional political conditions with respect to diplomatic recognition, arbitrary, that formally transcend in time the moment of admission of the applicant to the United Nations. Therefore, additional and arbitrary political conditions with respect to prior diplomatic recognition created as an effect additional illegal obligations, degrading the membership status of Macedonia, that finally, after dubious negotiations over the ID, resulted in the legal Prespa agreement, the harmful act endangering the very survival of the Macedonian state and nation. Members of the United Nations Security Council in 1993 didn't at the time realize that a dispute between two states may not exist under international law and over the state's ID, and as a final consequence of their ignorance emerged the Prespa Agreement, the Compromise Act for actual nullification of the national identity. PA appears to be at the same time an illegal treaty and illegal treaty, in blatant violation of jus cogens norms and basic rights of a state, and also acts in sharp violations and disrespect for human rights. Furthermore, the United Nations Security Council in 1993 essentially didn't realize that under international law, a state does not have the exclusive right over their state's name, and that the state's ID is the crucial and an inseparable legal element of the judicial personality that could only be a subject matter of recognition or not recognition, not of a dispute. On the other side, or on the other hand, the Macedonian government, the president, and the diplomacy did not understand or know any or all of those essential principles, and in fact implicitly accepted with no reason, or no reaction, I should say, with no reaction, disgracefully unlawful United Nations extra conditions imposed on Macedonia in the process of its admission to the UN. Both the UN Security Council representatives and the Macedonian diplomats, including the Macedonian president himself, actually have not observed or noticed or knew a principle that the state's name or any change of it do not affect the territorial or other rights of a state, nor create the rights or obligations of other states, vis-a-vis the others with that name. The main Greek argument of alleged Macedonian irredentism is in quotation, against Greece was in fact rejected by the International Court of Justice in 2011, Refer to judgment of the ICJ, Macedonia versus Greece 2011. You can check this yourselves. Based on apparently fake grounds, yeah, the Greek diplomacy successfully persuaded members of the UN Security Council that the applicant state with its name conducted a policy of irredentism. A same argument, or rather fake ground, later rejected by the ICJ 2011 decision. In addition, what Macedonian diplomats didn't realize at that time was that a chosen state's name could not be linked or affected by any historical political rights, since the historical political rights as an arbitrary category does not even exist in the modern international law. Apparently, unprofessional Macedonian diplomats were naively persuaded by skillful Greek diplomats on the importance of the historical narrative and needlessly started endless irrational negotiations over its name due to their lack of knowledge of international law and insufficient international experience. Even after delivering the legal opinion of the Badinter's Commission that only the Republic of Macedonia, opinion number 6, and the Republic of Slovenia were states capable for international negotiations, Macedonian diplomats in 1992 started naively and needlessly negotiations over the Macedonian national name under EC auspices, like some historical issue existed between the two countries that needed to be resolved. Rather, incompetent and amateur Macedonian diplomacy didn't explicitly refuse to negotiate over the name, that is an ID, capital I, capital D, even in the United Nations as a non-negotiable subject. And as a consequence of their fallacy, UNSC Resolution 817 was born. So they allowed for this resolution to be created as partially illegal document. Example, with illegal additional conditions embedded in it. Hence, absence of the basic legal knowledge and fallacy by the Macedonian government and its implicit consent for illegal negotiation framework didn't legalize the UN resolution, did not legalize the UN resolutions and its legal effects, since illegal acts do not create law. Illegal acts do not create law. Ex injuria jus non oritur. For those of you who understand Latin. I don't, but I'm assuming that's what it means. I trust the professor would know these things. From historical perspective, it should be noted that the chosen modern state's name per se actually may not necessarily be even linked to the antique or any historical period at all. These simple historical facts as ancient names or designations have no relevance from the point of international law whatsoever, says Professor Igor Janev. Needlessly to discuss, but even simple recent facts prove that the Macedonian nation was not artificially created in the 20th century, as the Bulgarians would argue, but much, much earlier, at least from the period of immigration of when all these people moved to the Balkan Peninsula. So the Greek argument that this new candidate for the UN membership may not use their antique name sounds ridiculous and misleading. Nevertheless, in the absence of understanding with respect to conditioning for UN membership and motivations of the Hellenic Republic, members of the Security Council have voted unconsciously for an illegal negotiating framework enshrined in the United Nations Security Resolutions 817, 1993, and then confirmed that by the United Nations Security Resolutions 845, 1993. Same year, two resolutions in the UN, 817 and 845, were that the state was actually stripped, the state of Macedonia, the country of Macedonia, the nation of Macedonia that we've known from the very beginning when we came to be on this planet. The state was actually stripped from its legal ID, that is the state's name, after the entrance to the United Nations. Furthermore, UNGA Resolution 47/225 was also partially illegal, imposing negotiations on new sovereign member state over its legal identity with the other state that does not recognize it, calling even other UN members for collective non-recognition. My goodness. It should be noted that the UN organization is an association of sovereign member states linked by a treaty, that is the UN Charter. Okay, we know it as the UN Charter. The members with equal sovereignty in accordance with the UN Charter, Article 2, Paragraph 1. Apparently, the state's legal identity is an essential and inseparable element of the international judicial personality of the legal person, such as a state. Please see AJIL Volume 93, Number 1. And the sovereign judicial personality as an inviolable category. That means matter strictly in domestic jurisdiction of the sovereign, a state where no external interference is allowed. Now we're going to continue the second part of chapter 6. And the professor says the following. Among other politically relevant aspects that were not fully realized by the Security Council, that is the United Nations Security Council, was that Macedonia at the time of admission to the UN, 1993, even didn't have an army. They did not have an army or military potential to be a threat to any country. Our research showed that in 1993, the Macedonian army hadn't had any sufficient budget for military uniforms and basic equipment and weaponry. On the other side, Greek army and security forces were so much stronger that they could very easily occupy a defenseless Macedonian territory practically in a couple of days, says the professor. Analyzing the situation, even from that simple set of facts regarding a distribution of powers, it appears that the UN Security Council in 1993 missed the basic information or perspective and made entirely wrong assumptions and therefore created a bad resolution. As we realized and have also mentioned it in this study, in this publication, the Greek ministers of defense, Kamenos, in 2019, reported to the Greek parliament before the ratification of the Prespa treaty that his army, that is the Greek army, can occupy North Macedonian territory within 20 minutes. That's what this person, the Minister of Defense, Kamenos, said in 2019, that they can occupy Macedonia and its territory within 20 minutes. Shortly after the ratification of the treaty, this is in 2019, frightened Macedonian government actually made a military deal with the Hellenic Republic that the sky over Macedonia will be guarded by the Greek Air Force. This is unbelievable. I'm going to read this again in case you didn't hear me properly. So, shortly after the ratification of the treaty, the Prespa agreement, the frightened Macedonian government actually made a military deal with the Hellenic Republic that the sky above Macedonia will be guarded, they say, guarded by the Greek Air Force. What is a foreign country Air Force doing above the country of Macedonia? What are they doing in the sky? How can a government give authority or approval for a foreign government military to be so-called guarding or protecting Macedonia and its sky? It seems to be more like what the minister had said, Kamenos, in 2019. They can actually occupy or invade Macedonia in a matter of 20 minutes. Amazing stuff. Amazing. So taking these facts into consideration, says the professor, there were never any threats from the Republic of Macedonia to the Hellenic Republic. I think it's the opposite, isn't it? They're flying. The Greek military, Air Force and whatnot, have got full control of the Macedonian sky. Okay, so what does that tell us? With respect to the fabricated name problem, in quotes, problem, it should also be noted that in Greece exists only one Macedonia, but 3 administrative regions, and that the name of the UN member candidate Republic of Macedonia was not the same as those administrative local names. In addition, the name Republic of Macedonia, it is apparently different from the name of antique Kingdom of Macedonia that existed in the period before Christ. As we concluded, the name of the state, the Republic of Macedonia, could not be linked legally to any so-called historical rights, time-sensitive and arbitrary categories, nor could have any impact on the territorial rights of states or affect any obligations of either state. However, a disgrace or blame for the most event or elements surrounding the groundless dispute creation in the UN history should not be solely on the UN Security Council in 1993 or the UNGA. The first president of the Republic of Macedonia, Kiro Gligorov, disregarding the mentioned opinion of the European Union Arbitrary Commission delivered in 1992 that Slovenia and Macedonia have satisfied the criteria for statehood, needlessly started to negotiate the name of its state, that is the Republic of Macedonia, and by causing problem issues. Gligorov naively, in fact, admitted that there was an issue between the 2 countries, creating worldwide issue. It beggars belief. President Gligorov, unprepared, came to the United Nations in 1993 and hadn't objected to the imposition of the disgraceful provisional denomination of FYROM, that demonstrating once again a fundamental lack of knowledge of international law. Well, if he didn't have the knowledge, he would have had people who were advising him, like lawyers or others who are experts on international law, like the professor himself. People surrounding Gligorov also didn't understand or know that disputes over the state's name cannot exist between 2 states under any circumstances in international law. So they didn't know, he didn't know. Where are all the brains gone? Apparently, Gligorov and his team hadn't any essential understanding of the basic concepts and principles of international law, particularly pillar principles such as non-interference in domestic jurisdiction and sovereignty or independence. Beggars belief, if you ask me. I'd be interested in your opinion. During the presidency of Kiro Gligorov, among other odd things, it has been inappropriate in Macedonian Ministry of Foreign Affairs to use the term as negotiations for that so-called difference, since Gligorov and the Macedonian governments never actually admitted that they were negotiating in a negotiation process with other states over the state's or national name. And Macedonian diplomats were instructed only to use vague names, yes, such as talks or discussions instead of negotiations as sort of a cover-up and the policy of denial. By policy of replacing or muddling through basic terms, government gave false impression that they were not negotiating the ID mainly for local usage. But it was tactics of short duration, since in the interim agreement with Greece signed in 1995, Macedonia explicitly accepted to negotiate, in quotation, negotiate with Greece as it was agreed in the text of the treaty. Has anybody got any marbles in their head over there? Seems not. Yeah, surprisingly, even the treaty was signed in 1995. Macedonian Ministry of Foreign Affairs and government continued to argue that it was inappropriate to use the word negotiations and a dispute instead of the term difference. Macedonian Ministry of Foreign Affairs and all public in Macedonia was unaware that 2 additional conditions for the UN membership were imposed in this process. Furthermore, that's also unbelievable. How can it be so? How can they be not aware? I mean, can they not read English or Macedonian or get it translated if it's in English, translated in Macedonia? Surely there would be independent translators who will render the meaning and the accuracy required. Furthermore, even after the revelation of these discriminating conditions, no one in Macedonia knew or understood that those were illegal conditions. As was explained to me, says Prof.d-r Igor Janev, one condition was the prosperous denomination, in quotes, the former Yugoslav Republic of Macedonia, or FYROM, that in fact couldn't serve as a legal ID outscope the UN. Second preposterous condition placed before Macedonia, or rather the FYROM, was mandatory negotiations with the adversary state over the national ID, meanwhile using only disgraceful provisional denomination until Greece was satisfied with the new national ID. Wow. Macedonian government hadn't grasped that in order to satisfy Greece's national ID, had to be completely nullified erga omnes, and that in nullification they had to participate. They didn't have to do anything. Only had they known, only had they consulted others who knew about international law and the United Nations Charter and all sorts of other important decisions made by the Council of the courts of the United Nations and their decisions. Yeah. So, not only that there couldn't legally exist disputes or difference between states regarding the state's name, but blackmails of that magnitude could not be justified under any circumstances, particularly since membership requirement was to possess basic judicial capacities featured by sovereign subject. Therefore, the so-called historical issues concerns served as a groundless justification and a trap for naive and ignorant Macedonian politicians. Shockingly, even after Gligorov's presidency, all the subsequent Macedonian governments also couldn't figure out or grasp that Macedonia was admitted in the United Nations as a nameless state, a state without a name, delicta omissions by UN, and blindly pursued with senseless negotiations. This point, the Macedonian leaders, in fact, have never questioned the decisions of others, learned that the states do not have an exclusive right over the state's name. In addition, the state's name, 1, cannot be imposed or deprived. 2, cannot be subject of theft. 3, cannot be subject of negotiation or contract or generally any regulation or imposition by other external instruments or acts from other governments or bodies. In addition, the change of the state's name could not affect any change of its rights or duties with respect to the other state's territory, nor have any effects on its own territory obligations or be interpreted as conferred rights or duties. Furthermore, the state's name change couldn't create any implications with respect to its own history, nor a history or historical implications with respect to other states and their sovereign rights. Therefore, says Professor Igor Janev, it is plausible to derive that all Macedonian governments and politicians from the very beginning of the creation of the Macedonian modern independent state, that is 1992 to 1993, to the present day, fundamentally could not learn or comprehend sovereign rights, and that they were completely played out by Greece and the international community, considering them as allies with good intentions. Are they? The Macedonian population thinks otherwise. Yeah, so that was part 2 of chapter 6, conclusions and some recommendations by Professor Dr. Igor Janev as part of his scholarly publication, The Prespa Agreement as Cultural Genocide of the Macedonian National Identity. We shall continue with part 3 and the rest of the parts until we finish this chapter. So thank you for your attention. You've been listening to In Focus with Silvana Pavlovska, broadcasting from Melbourne, Australia, independent journalist. And we're grateful to the professor for allowing us to bring this to the public's attention. I shall see you soon. Bye for now.